Welcome to the Galloway Law Podcast. My name is Thomas Galloway. Today's guest is Mark Kende, professor of law at Drake Law School. He is a James Madison Chair in Constitutional Law and director of the Constitutional Law Center at Drake. We spent a lot of time talking about the Supreme Court, political polarization on the court, the Kavanaugh situation, our Constitution, different ways to interpret it, and South Africa's Constitution. If you are someone who is tired of the current political media environment and you want neutral and informative interviews with legitimate experts, I think you'll really enjoy this episode and future episodes. So now to the interview. So I have some questions about the Supreme Court in general, and then a few Kavanaugh questions.
Sure.
Obligatory at this time. And the first question I have is, at the panel last week, someone asked a question about expansion of the court, and I believe it is you, correct me if I'm wrong, but that has been used in other countries, sometimes for somewhat corrupt and for political gain, shifting the court in size. Could you talk a little bit about those situations and what we can learn from that for our own court?
So it's risky because in countries like Poland and Hungary and probably some other countries that I'm not thinking of right now, but you've got people in power who were elected democratically, but actually they're pretty dictatorial, pretty autocratic. Once they took power, they were clever enough to actually use the democratic process to increase their power.
Right.
And one of the things they did was through either constitutional amendments or through a friendly legislature on their side, alter or increase the number of judges on the highest court in the country, or in some cases they did some things very clever like have age cutoffs, which basically eliminated huge numbers of judges from being able to be judges. So they essentially were manipulating the court system and who could be a judge.
Okay.
And when you have the president and along with the legislature manipulating the court system, you don't have separation of powers.
Right.
And when you don't have separation of powers, you have democracy endangered, because that's one of the core principles of this country is that, we have these three branches, they act as checks, and they provide checks and balances on each other. So that's what's happened in other countries. And then, we had a court packing experience here as well at the time of President Roosevelt, which I can talk about if you're interested, but certainly it endangers separation of powers and thus endangers having a real democracy.
Right. So he wanted essentially to progress a New Deal, is that correct? Was that his main goal in that process?
Yeah, so he was frustrated because all of his proposals to sort of expand the national government and have plans in place to help people during the Depression were being struck down by the court. He got them through the legislature, but they were all getting struck down by the court pretty much prior to 1937. And so he got frustrated and he proposed what's become known as the court packing scheme, where he said for every judge over a certain age, every justice on the Supreme Court over a certain age, I'm going to add another justice. Okay. And his argument was, these older justices, they're not in touch with what's going on.
Right.
And there's nothing in the Constitution that prohibits this. It's actually up to Congress to decide how many justices there are.
Right.
Congress came very close to supporting him. And what was interesting, though, was this was clearly a power play on his part, even though he was a popular president, to take away power from the courts to be independent.
Right.
And there were lots of political editorials, cartoons, even by people who supported him as president, saying this is like a dictator would do. And he did not ultimately succeed. But even though he didn't succeed, after 1937, interestingly, the court kind of got the message and started to rule in his favor anyway, without the additional justices having been added. So he may have accomplished his goal. He may have lost the battle but won the war, as they say.
Would you consider any situation to be advisable to have a changing in the size of the court, or is that something to try to stay away from completely?
I would say normally it would be something to stay away from completely. The one exception would be, and I'm not saying this will happen, but if the court became extremely extremely one-sided.
Right.
And that would go for either side if it were extremely liberal or extremely conservative.
Right.
And really almost started to lose legitimacy and started to be perceived as a body that was just a political tool.
Right.
There might be a reason to say, we've already lost in some ways the court's legitimacy. If we can add some justices who provide balance,
right,
that would help. Having said that, that is just an awful scenario. It would almost, even in that case, be better to just let the court play itself out and let the normal cycle take place of a new president coming in. Eventually you'll have Democratic presidents, Republican presidents, etc. So that would not be anything I would want to have happen except in the most awful cases. There are lesser mechanisms, though, that could be put in place that would not be as risky and dangerous as that might be beneficial, that I could suggest.
Right. Okay, so a couple Kavanaugh questions.
Sure.
First one being, throughout the Me Too movement, we've heard a little more about the people talking about the burden of proof, and then that has been applied some to the Kavanaugh situation, but then you have other people saying, well, it's more or less a job interview, and that is just not necessarily that we need proof, that it needs to be a concern about his fitness. I know it's a politically charged situation, but historically has that confirmation process been similar to a job interview in the way that we traditionally think of a job interview?
Well, it's definitely a special kind of job interview, if it's a job interview. I mean, it's occurring in public, it's highly politicized, there are people who are throwing millions of dollars into the pot on one side or the other, at least in recent years. If you go back much farther, there was even a period where you really didn't even have confirmation hearings. But, in recent years, it's become what I would call, and I think I've even used this term, sort of a political job interview on steroids. Mm-hmm. The unfortunate part is the political clashes with what you want this person to be, which is they're going to end up being a justice who you want to be not political. So it's a really awkward situation, which I think is what you have going on. The more politicized it becomes, you may get someone like Justice Kavanaugh, who, I think, in all fairness, I don't think there'd be disagreement about this, did play some political cards. He criticized the Clintons. He criticized a sort of conspiracy of people he said were contributing millions of dollars against him. But there were also people contributing millions of dollars in favor of him. So, but, he was, I think, at that point, willing to be somewhat political. And it's a job interview in my view. It's not, I don't think, a criminal court by any means. And that's where you get into the issue of what's the burden of proof. It is, though, a job interview that has special requirements because the person's not just getting an ordinary job, they're getting life tenure on the highest court in the land. So, I think there's a burden there that's just more than an ordinary job interview. Right.
So as far as the lack of composure that we heard about through his hearings, is that in itself somewhat disqualifying, or would you say the personal nature of the situation kind of not necessarily called for that, but what's the balance? What's your opinion on that?
I don't think his composure was good at certain points. I thought he demonstrated at some points a lack of the ideal temperament you want. I do believe that if he was, in fact, falsely accused, and we don't know whether he was, it's a little bit understandable why he would have strong feelings about that. But even then, I think it would have been possible to express those sentiments in a way that didn't, as I said, get so partisan.
Right.
And that would have been, I think, better for everyone and made things, in general, less political. Is that disqualifying? I happen to be of the view that alone would not have been disqualifying. There were other things about truthfulness, which is a different issue than temperament, that when combined with temperament are what I really think put him in a difficult situation.
Right. So in some of your publications, you talk about constitutional pragmatism. And I was hoping you could define that and then how that applies to cases that involve religious liberty.
So, lots of people have different views on how the Constitution should be interpreted, and there's really two fundamental views that you may have heard of. There are people who are called originalists, and they tend to take a very conservative, strict construction view of the Constitution, that the Constitution should be interpreted the way the framers who wrote it back in the 18th century meant it. They even emphasize using dictionaries back from the 18th century and taking words in the Constitution and finding out what those words meant in the 18th century, or if it's the Civil War amendments, the middle of the 19th century. And so that's one approach. It tends to be very conservative, tends to be backwards looking. To be fair, the advantage, it does sort of limit the court theoretically, although there's very strong arguments that, in fact, the people on the court who claim to be originalists are only originalists in some cases and not others, and therefore the criticism is that they pick and choose, they cherry pick.
Right.
Anyway, the living constitutionalists are sort of on the other side. The living constitutionalists believe that the Constitution, when it was drafted and when it was framed, the framers never intended for it to be read in a strict, narrow way, but they knew it would evolve over time. Some of the court's earliest decisions, you have very prominent justices. There was a famous Chief Justice named Marshall who, wrote about how this is a document that's meant to last for the ages and should be interpreted flexibly and should not be interpreted narrowly. The criticism of that viewpoint is, does that give judges too much power to make those decisions for themselves? They're not limited. The response to that criticism is, no, it doesn't give them too much power. It just acknowledges the reality that the world's going to be changing. We have one of the oldest constitutions, if not the oldest, in the world. So pragmatism is a theory that basically doesn't say we should ignore those two approaches. It doesn't say originalism is irrelevant, because even the people who are living constitutionalists want to know what the framers think.
Right.
And hopefully the originalists want to know about the policy concerns of the living constitutionalists. Pragmatism is basically asking the question, what's going to be the best result right now for our current time?
Right.
And in a sense, the way I interpret pragmatism is it's a little bit similar to the living constitutionalists, except it's separate in that you're really focusing more on questions about, what's the reality going to be on the ground. So I can give you an example. The abortion debate. An originalist would say, abortion, the framers would have thought was impermissible, illegal, etc. A living constitutionalist might say, gee, women's role in society has changed. This is a right that they now should have, just like, it took them a while to have the vote, it took them a while to work. A pragmatist might ask an argument like, well, what would be the consequences, the practical consequences, if you banned abortion? Oh, well, one of the consequences would be actually women would probably still get them, but they'd have to do it kind of in secret.
Right.
They would be at risk. Some women, prior to Roe versus Wade, died getting illegal abortions because they were done by people who weren't accredited, etc. So that's the kind of pragmatist thought that is not something the living constitutionalists ignore, but it's not as important to them. And a pragmatist thinks more along those kinds of lines.
Right. Okay, so it seems a lot of your research is also South Africa oriented. I have a couple questions about that, but first, can you just tell how you kind of got interested in that?
So I was a civil rights lawyer for 5 years in Chicago. Okay. I was always interested in racial issues. The law firm I worked for represented African American and Latino plaintiffs in voting rights, police brutality, and other suits in Chicago. And I had an opportunity when I was there, to develop that interest. Then when I went into teaching, I found out about a fellowship for a year in South Africa, and it was a fellowship that would put me there for a year and put me at a university as a visiting scholar, and it would have been 4 years after they adopted their new constitution, in which they were trying to basically demolish and did demolish the old system of apartheid
Right.
and institute a multiracial democracy. So for me, the idea that I could actually go to a country like South Africa with my interest in race relations and then see how a country that had this horrible system of apartheid was trying to overcome it through their courts and through their constitution was an opportunity I couldn't miss, and then I got the opportunity to do that, so that's how I got interested.
Right, okay. So if I read it correctly in one of the publications, it said that they have 12-year term limits for the justices.
Yes.
Is that correct?
Yes.
How did that come about, and would you see a benefit for us having something like that?
Absolutely. So that was what I was referencing. There are other things and other ways besides trying to pack the court, for example, here, that I think would make things less political. And so there's a proposal that's been around for a long time, actually, probably over a decade, that justices on the court only serve 18-year terms. The reason they came up with 18 years is a little bit complicated, but it has to do with the fact that senators serve 6-year terms.
Okay.
And it also has to do with the rotation of presidents. And it would guarantee pretty much that every president has probably 2 appointments.
Right.
And after 18 years, you could actually do this without a constitutional amendment. That's what's really interesting about this. After 18 years, you wouldn't dump the person off the Supreme Court. They would take kind of what's called senior status. Okay. And that is something that already exists. So when a federal judge who's on a lower court gets older, they take senior status.
Okay.
And when they're seniors in their status, they help out. Right. So, if someone on the court was sick, or they might travel and serve and help with other lower courts, which is what, for example, Justice O'Connor actually has retired from the court, but she, during the time of her retirement when she was healthier, sometimes sat on lower courts. So you could have something like that for the Supreme Court. 18-year term limits, that's still a long time, gives them the opportunity to become very good at what they do, and therefore also hopefully not be affected by politics, because the goal of life tenure was to say, let's not have them affected by politics. But 18 years is going to keep them pretty safe from having to worry about politics too. But it means that you're not going to have this weird phenomenon right now where it seems like not just President Trump, but presidents like Obama and others are trying to pick almost the youngest qualified person they can, who might serve 30 or 40 years. That's great that these people have good qualifications, but, you want the best person possible and not just based on age. And so the 18-year term limit is also a good incentive to prevent that phenomenon from continuing.
So that would be one thing that would help with the polarization on the court. What are some other possible solutions?
Well, I think that's really, in some ways, the big one. Another possibility, although there's a debate about this, is many people argue that the court does a lot of things in secret. Okay. And, they don't have televised hearings. Right. They have a lot of their decisions that are made behind closed doors, and you don't really know about them until they're released. Right. Some people think that if the court were more transparent, we don't know how they decide to take cases. Mm-hmm. When a lawyer loses a case and petitions the court, it takes 4 justices on the court to agree to hear the case. Okay. Now, it takes 5 for that person to win out of 9, right, but it only takes 4. That process is completely hidden. Okay. Some people think that the more open the process would be, the more of an opportunity the public would have to see what goes on, and that would be beneficial to our society. There are others who think that would only make the polarization worse. There are some who think that if you started to televise court hearings, the justices would start to act more politically. So there's a bit of a divide, which is why I say I think the term limits is really the key. And then the one last thing I would add is the court has a habit of writing judicial opinions, and the justices do, that are pretty one-sided. Right. So if you win on gun control, for example, on the issue of gun control and whether there is a right to bear arms, conservatives won on that issue. And Justice Scalia, I think, wrote the main opinion, and it's a really one-sided opinion. It's a good opinion, but it's really one-sided. Another justice wrote, I think it was Stevens, on the other side, wrote a dissent that was really one-sided. Now, these two justices were looking at exactly the same historical documents.
Right.
How is it possible for two such smart people to look at the same documents and read them in such a one-sided fashion? So one of the great things would be if the court were willing to, and it's hard because they're very divided. They get along well personally, but they're very divided politically and judicially. If the court could tone down sometimes its divisions and acknowledge the strength of the arguments on the other side. And there are some courts, South Africa early on had a policy and a practice where the majority and the dissent in a case would actually share their opinions with each other before they were released.
Okay.
And each side would try to improve the other side's opinion, even if it wasn't their opinion.
Right.
That kind of collaboration would be of great benefit, but I don't think that's likely to happen with our court in the near future.
Right. In one of your publications, it talked about the authors of South Africa's constitution and versus the authors of our constitution having a big impact on the final result, and with drastic, like a couple hundred years difference. And can you talk a little bit about that, how that the authors affected the final result of the constitutions in both those countries?
So, the difference is South Africa has people who were on their court, and some of those people helped write the Constitution.
Right.
And so it's interesting that despite that fact, when they wrote the Constitution, they wrote a Constitution that was unlike ours in that it was deliberately meant to be a radical, transformative document.
Right.
I mean, there was just no doubt they were trying to transition and get rid of apartheid and change the society. So there was just no dispute about that. So with that overall purpose, they have interpreted or tried to interpret, when cases come up under their constitution, they've tried to interpret the cases in ways that promote this radical change in society. I don't mean radical in a negative way, I just mean dramatic. Our constitution is much more complicated because, it's over 200 years old. Obviously, no one who wrote it, can tell the current justices exactly what they were thinking.
Right.
The justices are kind of on their own. Our Constitution is much thinner. It's very short. And it's very, very vague.
Yeah.
It's very, very general. So that just opens the floodgates for these justices to try to interpret it. And that's where you have the battle of interpretation. In South Africa, sure, the justices sometimes disagree, but actually on the fundamentally transformative nature of that document, there's no disagreement. As to whether our U.S. Constitution is a document that should be interpreted as transformative, there's a complete divide. The originalists would say no, generally.
Right.
They're conservative, they're strict constructionists. The living constitutionalists would point to the Civil War amendments, the 13th, 14th, and 15th Amendments, and say, no, actually, we had a period where we passed some amendments that were meant to transform our society from slavery.
Right.
So we have that divide. They don't have that divide, and they have justices on their court who were really the framers. And the funniest thing I think about it is those people on the court who are the framers have always rejected any kind of originalism in South Africa, and yet they're the people who could tell you what they were thinking. But they've said that wasn't the goal of our Constitution.
Right. I was going to have a question about the size of our Constitution and how, if I understand correctly, it was something that everybody could read and everybody could at least have a general idea what the people who were framing it were thinking. They could at least have access to it in that size. How does originalism really fit in with something that has so many implied rights and that is maybe not black and white? How does originalism really fit in with that?
I think that's the key problem with originalism. Not to say that there aren't problems with other approaches, but when you have a document that uses words like equal protection, due process, freedom of religion, that's not the exact wording, but and it's written such a long time ago, you don't have any certainty about what those words mean. And then you have people on both sides of the issue debating, that the framers meant for, on the one hand, for the Constitution to be interpreted pretty strictly, and that would be someone like a Justice Clarence Thomas on the court, probably Justice Gorsuch, and probably Justice Alito. And then you have other justices, I'm thinking of Justices Kagan and Sotomayor, who would probably say, no, actually, the framers didn't themselves want it to be interpreted very strictly. And since this all happened so long ago, you don't have an easy answer. So you do have that ambiguity, and that's what creates some of the tension. It's too bad, though, that the justices can't work a little bit harder sometimes on some issues to kind of acknowledge the difficulty of some of the cases and the fact that, this is a complicated situation, and show, a lot of respect for each other, which generally they do. The Kavanaugh hearing is sort of a rare sort of peek into the political aspect of the confirmation process. Once you're on the court, everyone seems to suggest, the court's members, conservatives and and Democrats and Republicans on the court get along quite well. In fact, the first day you may have heard Justice Kavanaugh was seated next to Justice Kagan. They don't share probably the same viewpoint, but apparently, they were having a perfectly cordial conversation and all of that.
Do you see political polarization on the court being directly opposed to constitutional pragmatism, that those would be at odds with each other?
Yes. So, part of the goal of pragmatism in terms of my notion of how that would work would be if the court was focused more on actual consequences as opposed to what I'm sort of going to use the term abstract theories, whether that theory be originalism or living constitutionalism. You might have a court that is able to then narrow its ideological disagreements, because then you'd be trying to figure out what are the real consequences of what's happening. That would be my hope. The reality might be different. There are cases where the justices do talk about actual consequences. I want to be fair. And there are cases where they see the consequences very differently. So it might not work, but to some extent, I think the more practical they can be, the more they can try to sort of take account of the real impact of their decisions on real people. To some extent, the more they might be willing on occasion to compromise. That might be a good thing for our society. It would diminish some of the polarization. It would make the reputation of the court, I think, become better. There are some people who think Chief Justice Roberts, as Chief Justice, is going to try to have the court become a court that compromises more, and that he's made that effort already in some of his sort of decisions and roles as a Chief Justice.
Right. We may have covered this in bits and pieces, but what would be the argument for originalism?
The argument for originalism is that I think the best argument for it is that it provides a limit to what judges can do. Justice Scalia has said, may he rest in peace, of course, but Justice Scalia said before he passed that, originalism at least limits what a judge can do to what the people at the time of the framing, whether it be of the first Constitution and the first amendments or the later amendments in the 19th century, if you look at what those words meant at that time, that limits what you as a judge can do. Take same-sex marriage. Okay? For someone like a Justice Scalia or some of the conservatives, their argument would be there's just nothing in the record of the 18th century framing or the 19th century Civil War amendments that shows that when they used terms like equal protection, etc., that they wanted to include sexual orientation. They would argue, therefore, what their approach does is it provides a limit to judicial power. And the power should reside in the elected branch, and that's the legislature and the president. That's, I think, their strongest argument. There are strong criticisms of that, but I think that's probably their strongest argument. And actually, it's kind of a practical argument.
Right.
There are other arguments they make that this is also the way the Constitution should be read, that you should always read it just like you would read any document, like a contract. What did the people who signed the contract intend?
Right.
But I think there are really strong criticisms of that.
Are there any more relevant differences you think between South Africa and our constitutions that we can learn from them that we haven't covered already?
Yes. One of the key parts of our history, it's not written about that much, but around the late 1960s, early 1970s, the court was relatively liberal compared to now. And the court started to think about, should we conclude that there might be some rights that people have that are fundamental, such as the right to education, the right to welfare if you're starving, etc. The court came quite close to actually concluding there were such rights, but in the end said no. And it's a complicated story as to why. But one of the arguments the court made, and there's several, so this is just one, was that no courts could ever implement those kinds of rights. How could a court decide and implement a right to education? How could a court implement a right to welfare? That has to be something the legislatures do. I think South Africa has disproven that one argument. South Africa's constitution has socioeconomic rights enshrined in the document, including a right to housing, right to health care, right to education. Their courts have had cases brought by people who were denied these rights. For example, they have cases where kids are so poor and live in such poor areas, usually rural, where they don't really have school books even to work with. Lawsuits have been brought, and their court has said, there are certain cases where the outrageous nature of the deprivation is so clear, and the remedy is so clear. I mean, there's no question, if kids don't have school books, the remedy is give them some school books or order the government to figure out a way to do that. They had a case where the government wouldn't provide a drug to people who had AIDS. The government wouldn't provide a drug that would literally save particularly pregnant women from giving birth to children with AIDS. And someone brought a lawsuit, a group brought a lawsuit, and the issue was the right to health care in part. And the court said, this isn't rocket science, and this isn't something that's improper for us to do. There is a right to health care here. If we don't do this, all these children will be born with AIDS and will die soon. And so we can, in those kinds of limited cases, not only rule on the issue of socioeconomic rights and say that they exist, but we can order a remedy. Our court has actually got language in it from these cases in the 60s and 70s saying that courts are not competent and are incapable of making decisions in those areas. You could argue from the originalist perspective that the court shouldn't do that, but I think the South African cases show that a court, if it wanted to, could actually do that within some limitations, and that's a lesson we could learn. Now, with a conservative court with an originalist leaning, I don't think that's going to happen anytime soon, but I think that's a major lesson we could learn. They also, on the death penalty and on racial discrimination, they're much more willing to sort of acknowledge that, for example, with the death penalty, and people have different views on that death penalty cases are very troubling because they often depend on the quality of the lawyer you have, whether you can afford a good lawyer, whether there's racial discrimination, who the prosecutor is, etc. In South Africa, they struck down the death penalty as unconstitutional, even though the public supports it, just as the public does here. But they said, look, we know there's racial discrimination. We know this kind of situation is going to depend on lawyers, and someone shouldn't be sentenced to death based on the accident of their birth as to whether they're poor or whether they're black. I think we could learn something from that in terms of, not to say we necessarily eliminate the death penalty, but we impose and we have a court that's more willing to look at that more carefully in a more pragmatic way.
So one of the publications talked a little about constitutional pragmatism in the cases of religious liberty situations in one U.S., South Africa, and Canada, I believe, one of your publications. Could you talk a little bit about how that was used in those 3 countries?
Yeah, so, the best example I can give is a contrast between the U.S. and Canada. So in Canada, they had a famous case involving a child. I believe he was of Sikh religious origin, Sikh, S-I-K-H. And to be a young Sikh male involves, as part of your religion, wearing essentially a kind of knife under a belt strapped to your body. And the school that this young person went to said, we have a no weapon policy. Right. So, and you can understand in most cases why that would be true. Yeah. The family brought a claim that violated the free exercise of religion rights of the family. And part of their argument was this could not be used as a weapon. It was strapped in such a way, belted in such a way, and just impossible to access practically for this kid. And he apparently had a good record, etc. As a kid, seemed very responsible, seemed really religious. Right. And this was a core religious part of, the faith of Sikhs. And their high court ruled in favor of the family on free exercise grounds. We have cases like that in which we have in American schools weapons policies. Right. And there have been some lower court cases a little bit like that. And, our courts have pretty quickly said no weapons. Right. The free exercise claim loses. Given what's been going on in the United States in terms of awful things happening in terms of schools, I can't say that's terrible. Right. All I'm just trying to point out is that there's a difference in terms of there's a little bit more willingness on the part of, in this particular case, the Canadian Supreme Court to sort of look very carefully at the pragmatic, factual situation on the ground of this kid and whether he was a danger. Whereas our court sort of, and our lower courts even, tend to sort of be more general and just sort of say, here's this policy, and we're not going to get into the details, because if we get into the details of every case, then that would be very messy, and just sort of conclude that we're not going to allow it.
Right. Okay. Well, thank you very much for taking the time today. I really appreciate that. Yeah.
Sure. Thank you. I appreciate it.